Good morning, everybody. Welcome to our latest webinar on contested wills. My name is Louise Igo. I am chairing today's webinar, and I am a partner here at Lodders and the head of the private client team. I'm confident that today's session will provide helpful information to those of you who are in the process of preparing a will or who may have specific concerns about a particular matter. I believe that our speakers have a lot of ground to cover in a short amount of time. So I do not wish to delay proceedings too much, but before I hand over to Jennifer Russell and Anjali Narshi, a few housekeeping items to cover. There will be a question and answer session at the end. However, please feel free to submit your questions throughout the session by using the Q&A button at the bottom of your screen. If you have any technical issues, please do raise a hand or ask a question, and we will endeavour to assist you. And we aim to wrap up the session around 11 o'clock. So first of all, I'm pleased to introduce you to our speakers, Jennifer Russell and Anjali Narshi. Jennifer is an associate solicitor in the private client team, and she specialises in wills, estate planning, tax and trusts, working with individuals, families and trustees. Jenny is a full member of the Society of Trust and Estate Practitioners and has recently been named a rising star in the legal directory Legal 500. Anjali is also an associate solicitor in our dispute resolution team. She specialises in contentious probate matters. Anjali advises clients on a broad range of contested will and trust disputes. So they're usually executors or beneficiaries under a will, or individuals who have been left out of a will. So I will first of all hand over to Jenny to start us off.
Thank you, Louise. When preparing wills for clients, my colleagues and I are always mindful of whether there could be any potential grounds for challenging the will. And if there are, we take steps to try to mitigate this risk as far as possible. There are various grounds for challenging a will under English law, and we will look at some of the most common ones during today's webinar. These include want of due execution, undue influence, lack of mental capacity, and claims for reasonable financial provision under the Inheritance Provision for Family and Dependents Act 1975. Starting with one of the most basic grounds, a will can be challenged for want of due execution if there is a concern that it has not been signed and witnessed correctly. Whilst there are certain exceptions, for example, if the person making the will, known as the testator, is on active military service, usually the following rules apply. The testator should sign the will, or if this is not possible, they can instead make a mark, such as a thumbprint, or direct someone to sign on their behalf in their presence. Most wills must be signed by two independent adult witnesses, who should be present when the testator signs the will. If a named beneficiary witnesses a will, whilst this does not invalidate the will, it does invalidate the gift to them, and so he or she should not act as a witness. As a result of the COVID pandemic, new temporary rules have been introduced to allow for wills to be witnessed remotely via video calls if physical witnessing is not possible. However, electronic signatures are not permitted. By instructing a lawyer to prepare a will, we will oversee the signing of the will to ensure that all is in order, either by meeting with the clients in person and acting as witnesses ourselves, or by providing detailed instructions as to how the will can be signed at home. It is important that nothing is attached to the will at any stage, for example, a covering letter attached with a paperclip, as this could leave a mark, suggesting that another document was attached to the will when it was signed and formed part of the will, potentially leading to queries after the testator has died. It is also important that the will does not show any signs of attempted destruction, such as tears, as this could lead to inquiries as to whether the testator attempted to cancel the will by destroying it. We would usually store wills on behalf of clients and would check the physical condition of the will before storing it safely away.
Thank you, Jenny, and good morning, everyone. As Jenny describes, the formal requirements surrounding how a will must be signed and witnessed are important. If a will fails to comply with these rules, it will be invalid and the estate will then pass either in accordance with an earlier will, if there is one, or if there is no earlier will, then in line with the intestacy rules. The most common challenge brought under this ground is an argument that the testator's signature has been forged or that both witnesses were not present at the same time to see the testator sign his or her will or acknowledge their signature. Now, neither challenge is an easy one to bring, and the success or failure of a claim depends on the facts and evidence before the court. This usually includes hearing oral evidence from the witnesses and considering reports from a handwriting expert in relation to the signature. The recent case of Rangel and Brunt 2021 is a great example of the challenge which the courts face. Here, when Mr. Brunt died, it was thought that he had no will, and so his estate was distributed in accordance with the intestacy rules. However, 10 years later, a will from 1999 was suddenly discovered when an office cat knocked over some papers in a consultant's office. There he is, trying to hide under the desk. One of the beneficiaries under the will brought a claim for an order that the estate should be redistributed in line with the terms of the will. This was challenged by some of Mr. Brunt's family, who said that the will was a forgery and had been prepared and signed by an individual who had a previous conviction for fraud. The High Court decided that the will was valid on the basis that the attendance notes were good evidence and the witnesses were reliable. However, the Court of Appeal later overturned this decision and ordered a retrial, stating that the High Court was wrong to use the attendance notes as a starting point, given they were being challenged, and they should not have ignored the handwriting expert's evidence. It will be interesting to see what happens at the retrial, but this case is an important reminder that the court will consider all the evidence before it, and it raises the possibility that even 10 years on, when all the inheritance could have been spent, the estate may be collected on and redistributed. I will now hand back over to Jenny, who will look at the next topic of undue influence.
Thank you, Anjali. If a person making a will has been unduly influenced by someone else, this could invalidate the will. Whilst it can be difficult to ascertain whether a client is being unduly influenced, we will take steps to satisfy ourselves as far as possible that there is no such influence. For example, by seeing the client on their own, away from family members, to check that their wishes for their will are their own. We will also discuss with the client their reasons for any significant changes from earlier wills.
Thank you, Jenny. As Jenny describes, the contents of a will must represent the testator's true wishes. If they don't, the will could be held as being invalid. The test which the court applies is summarised in Edwards and Edwards 2007. Essentially, it explains that undue influence means influence exercised by coercion or fraud. Coercion is pressure that is so great that it breaks a testator's own free will, and they give in to the will of the person exerting the pressure, usually for a quiet life and to keep the peace. Therefore, family and friends may make suggestions and try to persuade the testator, as to how they should leave their estate, but it will not amount to undue influence unless it can be proved that the will no longer reflects the testator's own true wishes, but instead reflects those of the person exerting the influence. There is therefore a difference between mere persuasion, which is allowed, although not ideal as it raises suspicion, and coercion, which is not allowed. This means that the testator may dispose of his estate however he wishes and regardless of how unfair it may seem, so long as he acted as a free agent. Undue influence claims are therefore particularly fact sensitive and difficult to prove, not least because the testator, who is the main witness, will have died by the time the challenge is brought. And acts of coercion usually take place in private when there is nobody else around. The case of Ri Chin, 2019, however, is an excellent example of a successful claim being brought under this ground. The case involved a Chinese family where a mother had made a will leaving her £3 million estate to her 5 daughters. This had been a source of tension between her and her husband, who believed that the family's wealth should pass to their only son, as their daughters were all married. Her husband had already transferred most of the family's wealth to their son when he got married. However, the mother believed that her daughters should be treated equally and as part of the family, especially since they helped run the family Chinese takeaway business. The matter came to court when it was discovered after the mother's death that she had suddenly and without any explanation changed her will, with the effect that her entire estate passed to her son. The daughters argued that their father and brother had exerted undue influence on their mother. Their father was an abusive and controlling character, and after their mother suffered a stroke, she had been prevented from having any contact with her daughters. In addition, their mother did not speak English, and the translator who translated the contents of the new will over to their mother had a poor grasp of the English language. The court found that no good reason had been shown as to why their mother changed her will, and that she either did not know and approve its contents or had been unduly influenced by her husband and son. Therefore, the new will was held to be invalid, and her residuary estate passed to her 5 daughters in line with her older will. This case shows that cases on this ground can succeed, but the court will look at all the circumstances surrounding how a will was prepared. One of the first things which we can do when presented with a challenge on this ground is investigate how a will was prepared. If it was prepared by a solicitor, we can make a very specific request that a statement be produced explaining the circumstances, as well as a copy of the will file and all attendance notes prepared so that we can better understand what has happened. I will now pass back to Jenny, who will talk about the third topic on our agenda, which is about lack of mental capacity.
Thank you, Anjali. For a will to be valid, the testator must have the necessary mental capacity to put a will in place, which broadly includes, firstly, understanding what a will is and its effects. Secondly, understanding the extent of their assets passing under the will. Thirdly, understanding their moral obligations to people it could reasonably be said that they may owe a duty. And lastly, having no mental disorder which would influence their will and cause them to dispose of their assets in a way in which they would not otherwise have done. As lawyers, when taking instructions from a client, we will assess the different elements of the test and keep detailed notes in case there is a challenge in the future. If we have any concerns, we would suggest that the client obtains a report from a professional to assess their capacity.
Thank you, Jenny. As Jenny explained, if there is an issue over the capacity of the testator, this could invalidate a will. We will now consider what might happen where a will is challenged on the ground that the testator lacked mental capacity to make a will. Court cases involving a challenge on this ground can become very costly very quickly. And whilst you cannot prevent someone from issuing proceedings, the chances are that if the steps which Jenny mentioned are taken, you will probably avoid the matter progressing to a fully contested trial. There are a few interesting cases which show how the courts have approached claims under this ground, and we can look at these next in the order that they appear on the slide. The case of Vegetarian Society in Scott 2013 involved a testator who suffered from schizophrenia. The court decided that the presence of a mental illness would not by itself automatically invalidate a will. Instead, it is the effect of that mental illness on the testator's ability to make a valid will, which would need to be considered carefully. Therefore, where a mental illness exists, medical expert evidence will need to be put before the court, and this can present a hurdle if the report was not prepared before the will instructions were taken, as we'll see next. In Hughes and Pritchard 2021, the medical expert had concluded that the testator did not have capacity to make a valid will. However, the court disagreed with this and determined that the will was in fact valid. It said that the expert was looking at medical papers in retrospect. He had never seen the testator and neither had he ever seen the witnesses. In contrast, the court had had the benefit of hearing live evidence from witnesses who had met the testator. The court said that all the evidence as a whole must be considered, and it would not simply follow the expert evidence put before it. The issue of whether a testator had capacity to make a valid will is for the court to decide. This case is therefore an important reminder that medical expert evidence, when obtained after the event, is not conclusive, and the question of whether a testator satisfies the criteria as set out by Jenny is a legal test. The recent case of Goss, Custard and Templeman 2020 looked at the importance of solicitors' attendance notes. Here, a solicitor had been tasked with preparing a will for Lord Templeman. He had dealt with Lord Templeman previously, and his attendance notes recorded that Lord Templeman was more forgetful than he had been in the past. The expert medical witness said that, in his opinion, this showed that the solicitor was alive to the issue of capacity. He had considered that something was not quite right and had assessed the situation. He took Lord Templeman's forgetfulness into account, considered all the circumstances, and then made a decision in relation to whether he felt Lord Templeman had testamentary capacity to make a valid will. In contrast, had the solicitor noticed nothing or carried on regardless, even when there were obvious problems, it would have been more problematic to say that the testator had capacity. The court agreed with the expert witness on this point. The case is therefore a reminder as to why it is so important for there to be clear attendance notes from the time at which the will instructions were taken, and just how important the court will consider the solicitor's evidence. One of the very first things that we might consider doing when an individual wants to bring a claim on this ground is whether to enter a caveat. This essentially stops a grant of probate from being issued and the estate from being distributed, and allows time for the matter to be investigated further. I will now hand back over to Jenny to discuss our next and final topic of claims brought under the Inheritance Act.
Thank you, Anjali. Whilst under English law, a person is free to make a will on any terms they choose, if certain people connected to the testator feel that he or she has not made adequate financial provision for them, they can bring a claim under the Inheritance Provision for Family and Dependents Act 1975. If successful, a judge can set aside some or all of the provisions of the will and order that financial provision be made from the testator's estate for the claimant. The categories of claimant include spouses and civil partners, children, including adult children, financial dependents, and cohabitees who have lived with the testator for at least 2 years. Whether such a claim is successful will depend on various factors, such as the wealth of the testator and claimant and the claimant's needs. If a client instructs us to prepare a will which excludes someone from the categories I've mentioned, we will explain that there is a risk that a challenge could be brought. If the client still wishes to exclude them, and there may be very good reasons for doing so, we would suggest that they prepare a letter setting out their reasoning, so that if a challenge is brought, this letter can be taken into consideration by the court. We can also advise clients on ways of structuring their wills in such a way as to keep all the family members happy as far as possible. For example, a common source of potential arguments can be where a testator has remarried and has children from a previous relationship, with the spouse and children both feeling that they should benefit from the will. One option could be to include an interest in possession trust for the benefit of the spouse during his or her lifetime, or until the spouse remarries, if the testator prefers. This means that the spouse is entitled to receive the income from the testator's assets, such as interest and dividends from their savings and investments, and occupy the testator's share of any residential property rent-free during their lifetime or until they remarry. However, the capital value of the assets does not belong to the spouse outright, and so cannot be given away during their lifetime or by will, meaning that the capital can pass to the testator's children when the spouse dies or remarries. The trustees can also be given the option to pay or loan capital from the trust to the spouse while they are alive, if the testator wishes.
Thank you, Jenny. The Inheritance Act is the basis upon which most challenges are made, because although a testator's will may be valid on the face of it, a disappointed beneficiary may still consider it unfair, or where there is no will, the intestacy rules will fail to provide for someone such as a cohabitee or stepchild. A claim of this nature must be made within 6 months of the grant of probate being issued. If this time limit has passed, an application for permission to issue a late claim will first need to be made, with a good reason as to why the claim was not made within the time limit. If the court is satisfied with the reasons given and grants the application, the claim will then be allowed to proceed to trial. In recent years, the courts have taken a much more lenient approach towards granting applications. For instance, the decision in Busat and Patel 2019 is the longest reported time extension ever granted by a court for a claim of this type. Here, the court decided that the obstacles which the claimant faced, such as her lack of education, financial hardship, cultural background, and poor English, were all good reasons for bringing an application almost 26 years after the time limit to issue her claim had expired. Therefore, whilst the need to bring an application for permission to issue a late claim is not fatal to a claim being heard, it does create an extra hurdle. It is therefore important to act quickly and remember that the facts surrounding each case will be different. There are many cases in this area dealing with all the different types of claimants which Jenny mentioned. The most important thing to be mindful of, however, is that where a spouse has been left out of a will, they are entitled to receive provision from the estate whether or not it is required for their maintenance. This means that, generally speaking, they often have the strongest claims. For all other types of claimants, the courts will only interfere with the will and make an award which caters for the claimant's reasonable financial needs. This means that the outcome of these cases will depend predominantly on what the financial assistance they need and they can show that they reasonably require, bearing in mind the size of the estate and the interests of all other beneficiaries. An example of this is a claim I was once involved in. where we acted for a client whose wife had changed her will only months before she passed away, and whilst she was in a care home. She effectively disinherited her husband so that her entire estate passed to her children from an earlier relationship. Our client was retired, he had very little by way of savings, and was being faced with the prospect of being made homeless as a result. We took steps to try and negotiate a settlement, but unfortunately this was not possible, and so we had to issue a claim under the Inheritance Act together with a lack of capacity claim to protect his position. Once the claim was issued, we made several more offers. However, the claim only settled on a Sunday afternoon, which was the day before a 5-day trial was due to start, largely because the other side's barrister managed to persuade the deceased's children that a settlement should be reached, given that our client was a spouse of the deceased, and the court would therefore make an award regardless of whether or not it was required for his maintenance. We were able to secure 45% of the value of the estate for our client, together with the majority of his legal costs, which was a good result. Although the property did have to be sold in this case, the value of what he received meant that he was able to purchase another property for himself, and this gave him a clean break. If this is not possible, perhaps because the value of the estate is not quite large enough, the court can consider granting a life interest in a property instead, as housing is considered an important need.
Can I just thank everybody for attending today's webinar, which hopefully you'll find interesting and useful. I mean, it is still the case that nearly 60% of people in England and Wales are without a will. So whilst we have issues with disappointed beneficiaries, I'm sure there's issues with wills being out of date out there as well. But it is increasingly important to ensure that your will is prepared properly. I saw a statistic research by Direct Line, which said that 1 in 4 would be challenging an estate. So there is a shifting trend towards this. So ensuring that advice is sought to minimise any potential claim and that the will is prepared properly is more so important. So thank you for attending today. There will be a recording of the webinar and the Q&A session on our website in due course, and we would be interested to receive your feedback or thoughts about future topics that you would like us to cover. And of course, if you would like to explore any of the topics that have been covered today further, please do contact us and we'd be happy to help. So thank you again to Jenny and Anjali, and thank you to everybody for coming.
Thank you.
Thank you.